being informed is the best way to calm a lot of your fears about this, right? Is that, okay, let's understand what's happening and let's see how it's developing and what checks and balances are being put in place. But ultimately, the idea that this has to be an industry that's unregulated and unchecked, someone has to think about it differently, because we know how that plays out when industries have no boundaries. And I don't think we have faced a tool or a product that's this powerful before, other than the atom bomb, maybe, right? There has to be some safeguards put around it. And the owners of these products have to understand, well, do you want your product to have longevity, or do you want to just make the most powerful thing that then just blows everything up? And that's a reality that they have to come to grips with.
Fortunately, on the regulatory side, and this just popped up in my feed just now, OpenAI is coming out with a new product called Skynet. It's supposed to be a perfect regulatory process. Howdy, and welcome to the show. This is another episode of the Tech Broadcast in terms of covering AI and all things tech and AI related in law and law adjacent. I'm blessed with Shahrad Milanfar's presence today. And unfortunately, Marshall cannot join us, but thank you for joining us, Shahrad.
Of course.
So, and we have quite an agenda today. I think the first place that we should probably start in terms of alpha and omegas is on social media trials. Since we last spoke about them going forward, there have been some verdicts that have come in.
I think last time we talked about the fact that Meta and Google were in trial in Los Angeles with Mark Lanier and Rahul Ravapudi and some other great lawyers. And they were able to obtain, I believe, a $3 million compensatory damage award and $2.1 million punitive damage award. And I believe a $900,000 award against technically YouTube, which is a division of Alphabet. And then there was another case in New Mexico that resulted in a $375 million verdict as well. And, you know, it's interesting that the big verdict is coming out in New Mexico as opposed to Los Angeles, but that just shows that other parts of the country are waking up and holding corporations accountable.
The thing that interested me in New Mexico was that was brought by the state itself in terms of violation. So there's a $5,000 per violation penalty that the jury found $375 million worth of penalties against Meta.
Yeah.
And that, again, was for violating consumer protection laws and the lack of safety related to children and addiction. So one of the things that I found interesting about this was these might be some of the first cases that we're going to see with similar fact patterns. Did you have any sort of takeaways as far as your practice in terms of potential people calling or issue spotting when there are potential calls?
Yeah, I mean, when I was doing defense work, we did a lot of product liability work for the auto industry, right? And when you think about a traditional product, you think about a car, a blender, or something that you're tangibly using. And now we have these AI systems that are becoming far more advanced. And I think the innovative thing that they did in that Los Angeles case was go after it as a product liability case. And these companies have to understand that while no product is perfect, having products out there that addict people or harm people or tell people to go do unthinkable things, and take their own lives are going to have consequences, and that these are things that they have to consider in their design of those products. But what's, I think, difficult and interesting is that when you're creating a product that's supposedly training itself and teaching itself, the question is, how are they going to put the proper boundaries or bumpers on it so that the product doesn't make decisions that are going to harm harm human beings, and to do it in a reasonable way. And I think this is the part that this industry is struggling with, because I don't know if they understand what they're unleashing in terms of how this product is evolving as it's going along.
Agreed. And in the area of uncertainty and fear, whether rational or irrational, probably the next place to go are the attacks on Sam Altman's house in San Francisco, and the attempted firebombing of OpenAI.
Yeah, I mean, the reports came out, and I think the guy has already been charged with attempted murder for throwing essentially a Molotov cocktail, I believe, at Sam Altman's house in San Francisco. And this is, to a certain extent, building with people's frustrations with AI and information, whether it's good or bad or misinformation that they're getting. And then apparently he went down to the offices of OpenAI and threatened to set the building on fire. So these are all things that are there. But and interestingly enough, a lot of these AI executives are building bunkers in their homes or vacation homes, which is kind of curious in terms of why those things are necessary. But it's unfortunate that his family had to go through that. But this is kind of indicative of the frustration people are feeling over the news that constantly is coming out about how AI is going to take everyone's jobs.
Yeah, I found it interesting that this individual was upset enough, and then obviously there are levels of mental health that can correlate with these types of actions, but was upset enough to have traveled all the way from Texas to do this, and then in short order there were shots fired in Altman's neighborhood, and those shots also hit his house. Separate incident.
Yeah, and I don't know I don't believe I've seen anything that indicates that was targeted at him, but it's just the convergence of horrible things that happened at or near his house during the past few days.
Yeah. I guess parallel to AI and kind of the magnitude of the changes that really caught me unaware, I'll share with you that just before we were to record today, the team that does IT work related to our firm was here, and he was really stunned by Anthropic's Mythos. It was something that quite honestly I had not heard of, but within the last week, a Claude adjacent product, Mythos, had uncovered numerous zero-day exploits. And for those who are not familiar, when operating systems come out, there are sometimes ways that one can penetrate the operating system and get through security. I think the reason our IT person was so concerned about it, and in fact, he commented, mark your calendar, this is the week where security changed, that we really, going forward, are going to reach a point where it will be near impossible to lock down the information that we have, even with two-factor authentication. This is now my monologue. My question to him was, you do our IT work and you've been doing this a long time. What recommendations do you have as far as a business is concerned? And paraphrasing, when he in essence said, pray. Things are going to shift and that there will be very little that we can do about it.
When you look at this issue, right? I mean, before, when you had the, all the encryption that was developed over the years, I always think about like a hacker, so some kid sitting in a basement and, coming up with creative ways to try to hack a system. And now the problem is that when you have supercomputing involved, the number of calculations that this thing can do in a millisecond is something that essentially is probably the factor of trillions of times faster than we were able to do before. And that's what encryption really was based on, is the fact that it would take them, years and decades to break it if they were able to do it. And now you've got machines that can do it very quickly. And the question is, how vulnerable are the systems that are out there? And how is that going to impact the big picture? And with this Anthropic product, Mythos, apparently it wasn't a closed system. Like, it had no internet access. And somehow it managed to figure out and exploit the, whatever ports that were available to it, access the internet, and then go out and essentially post on a chatbot platform which then caught the attention of security researchers, and that's how they figured out what had happened. And this is something that Anthropic, to their credit, has raised the flag on and said, "Hey, look, this is now where we're getting to, and all these companies need to be aware of what they're about to do."
To follow up on that piece, Anthropic did not release the product to the general public. They gave it to the software manufacturers to help find these vulnerabilities so that it's the software companies who are aware of them and can fix them. But some of the vulnerabilities, I think one was from a 27-year-old operating system that had just never been found by any of the hackers out there. So what the raw magnitude of computing power has been able to turn up is really quite interesting.
Yeah, and interestingly enough, the Alphabet or Google CEO was, in a segment of 60 Minutes, kind of talking about how the U.S. must be responsible in the development of AI. So we'll see how companies like Google, who are the leaders in this industry, are going to lead in trying to make this a more ethical or responsible growth, as opposed to just unleashing this and hoping that things go well.
I appreciate that. I think the challenges, and we've seen this with other AI products, but with Mythos, yet again, they don't know exactly how it is doing what it does. It's almost as if we are reaching the point where we, from a technological standpoint, analog, the human body. Doctors have been working for millennia on the human body, and we're still kind of at a very base level in terms of understanding how it works. Now we have software AI tools that are beyond our capacity of understanding how they are doing what they do.
Yeah, and I mean, that's goes to the analogy I think we talked about was, if there's a black box that you don't really know what's in it or what it's capable of it, but we're keeping it fed and basically giving it more and more information and energy to develop. And once that supercomputing piece is in there, if it's smarter than us, and if it's able to access resources in a way where no single human being on its own can do, then obviously that's going to be an issue in terms of how do we control what it does and how it reacts to things as it grows and gets more and more powerful.
I'm getting an image of the plant from Little Shop of Horrors from way back in the day. Steve Martin, Red Browness.
We're now dating ourselves, I should say.
When I make reference to movies that have been filmed before a lot of our listeners have been born, that is an issue. But yeah, it is an oldie and a good one.
Yeah, fortunately, I've made our kids watch the movies I watched as a kid just to get them to understand the humor as it comes out.
In a parallel vein, product liability as it relates to AI, you brought up the dancing robot and the dancing robot fiasco, which we'll put a link to in the show because it is stunningly amusing and a little frightening if it had gotten out of control in a different way. But I'd be interested in your thoughts on that on the product liability side.
So just to give the audience context, so in the last couple of weeks, there was a video that came out of a robot that was, a little robot in a restaurant that dances around and entertains the customers. And the robot had a malfunction and started kind of beating on a table. And one of the poor servers, whose look on her face is like, I don't get paid enough for this stuff, is trying to hold this thing back. And it keeps, dancing and hitting the table. And it made me think like, all right, you've got these robots, and there have been sightings of robots walking around different cities around the United States. And China did an incredible demonstration of their robots. I don't know if you saw that, but these robots were basically performing like Shaolin monks at some sort of a country function. And their ability to do backflips off walls and balance was just phenomenal. So the question is, all right, when you've got a robot, and if that robot malfunctions and punches somebody in the face or, hurts a child or something like that, the product liability consequences that it's going to have. And then, what about the business? Is the business liable for the robot's actions? Is the manufacturer? What kind of a document did the business sign to purchase that robot? It's going to be an interesting onion to peel back as these things become, part of our lives. And I don't know if you heard Elon Musk talk about his $1 trillion pay package, but one of the things he said was, I need essentially 25% of Tesla's stock because I'm building a robot army and I want to make sure nobody wrestles the control of that army away from me.
When I think about people that I want in control of a robot army, I cannot think of anyone else who makes me feel more. Well, maybe our commander in chief, but that those two, I think, would be the ones I want to have.
Yeah, so it'll be interesting to see how this happens, and then you've got cars driving on the wrong side of the street and hitting pedestrians, or you have these delivery robots now just blocking fire trucks. Right? The fire truck doesn't get to the person's home. Somebody dies in that fire. You've got potential liability there. So there's a lot of things that could happen. And sometimes I see the stuff that's occurring and you think, well, you can't really make this up. It's just amazing that these things are occurring now.
Yeah. On the law front, I went to a wonderful Bar Association of San Francisco event that talked about AI and the law. And one of the areas that they focused on were some issues related to some new cases that have come out. Law is trying to keep up with AI on the evidence front, which is always an interesting. Can law move as fast as tech? Usually not. And so from an evidence perspective, looking at some of the rulings are interesting. The rulings that certainly caught my attention in terms of being cautious with what we do and what we advise our clients to do and what impropers do. And I'll just give a brief summary of these. And again, we'll link to these in the show notes. United States versus Heppner was a case where a criminal defendant took areas that the defendant had questions about, plugged it into AI, and ultimately this was located when a device was seized. And the judge determined that the questions that the criminal defendant were asking about his own potential criminal liability were things that were discoverable and could be shown to a jury. The piece there that I thought, and Shahrad, I would be interested in your thoughts in terms of how that filters into our practice. I'm guessing that you have had clients who have come to you with their own research. Like, thanks for your demand package or your mediation brief or whatever it is, but I've done some research and it tells me that my case is worth this or that we're going to win because of Y. Has that come up for you?
It did recently in an interesting context, and that was that we'd already settled the case and the settlement agreement was sent to the client, and then we got feedback, and one of the pieces of feedback was, I want these changes made to make the agreement conform to the standards that are acceptable in the industry, which were not things that I had seen in, over, 20 some odd years of practice. And the client also, had an idea that the funds should be paid before the settlement agreement is signed. And again, I've done both defense, plaintiffs, and mediation work as a mediator. And again, more power to you if you can pull that off, but I've never seen it done. So those are things that they genuinely believed that this was the way to do it. And, it got to a point where I had to basically say, look, you have to trust me. They're not going to somehow do something shady. And, I've dealt with these lawyers and this particular, insurance carrier, and I've never had an issue. I don't know anybody else who's had an issue, but it creates legitimate concerns. And in fact, as a side note, which is interesting, there was a real estate agent in New York who posted that he had some $50 million deal going, and both the seller and the buyer went to OpenAI's ChatGPT and said, hey, am I overpaying or not paying enough or not receiving enough? And it gave them both opposite information. Like, it told the buyer you're overpaying. It told the seller you're not getting enough money. So it just kind of goes to show about the lack of consistency. And again, going back to one of our early episodes, these systems are people pleasers, and how you ask the questions could cause the answer to be very different than if you were to do it in a more, in a different way, I should say.
Part of the reason I brought that up as a foundation piece is I think most of us in practice are starting to see clients or potential clients are using AI as a way to get more insight into the mystery that is law. And I don't begrudge a client or potential client for doing that. Where this particular case, US v. Heppner, caused me concern is we know that one of the things that shows up in a lot of our cases are discovery of social media. That's just kind of standard. It shows up in interrogatories and requests for production, et cetera. The next evolution of this very likely seems to be a demand for all conversations case related with your AI tools, because arguably under US v. Heppner, that they would be discoverable.
Well, I mean, but US v. Heppner, in my opinion, was slightly different, right? It's basically a criminal defendant putting this stuff in there, and then that computer getting seized or by a actual warrant, not an administrative warrant, a real warrant. So that was a little bit different in my opinion, but at the same time, it is something that's concerning all around because it cuts both ways, right? If the defense asks for that, we may ask for the defendants, chat GPT conversations, which could open up a whole can of worms that they don't want to go down. And so I think it bears, saying that all of our clients should be cautious in terms of what they put, because on social media, nobody puts down that, hey, I'm in pain in my back and I can't move today. They're always putting on a smile and that sort of thing. When in fact, in a chatbot, it may be very different because they're seeing that chatbot as a confidant and they may be more open about what they're going through. So who knows how that's going to play out? But, since this came out, I try to tell our clients, look, don't go doing something like this because it could have, consequences.
That was the point that I was ultimately trying to get to is while it is uncharted territory, it could very well be an area that becomes a nascent discovery region where people's questions, because it's not a attorney work product. It's a client having a conversation with a third party tool.
And I wonder what if the client was given a login or an account by the attorney? The Heppner case may have written very differently because that may have been seen differently by the court, but that issue was not present. It was somebody doing it wholly separately and going in and putting that information in before they even provided the information to their own attorney.
That's a perfect way to kind of get into Warner v. Gilbarco, which is an Eastern District of Michigan evidentiary ruling, federal court case. And in that case, the plaintiff was a pro se plaintiff. The pro se plaintiff was using ChatGPT to draft legal material. And in that case, the court found, look, the pro se litigant using chat to help come up with legal material, that's a tool. That's not something that is discoverable, and so that does go to potentially your notion that if it's within the confines of litigation, there is protection for it.
Well, and I wonder if that argument was made in Heppner, that at the time he was doing this, he was pro se, and therefore he was simply using a tool as opposed to, somebody who's represented by an attorney. I don't know the answer to that, but I don't, and it would be interesting to figure out if that would have made a difference in the judge's ruling.
My loose memory of Heppner is that he was a fairly high, this was a white collar fraud, fairly high up executive, had an army of lawyers. So the pro se side probably would have been a hard argument to make.
Who clearly he did not trust because he wanted to open AI.
Yeah. The corollary thing that came up for me was the issue of AI transcription versus AI note taking. And I raise this because so many people use Zoom or Zoom variant meetings these days, and there are so many AI transcription tools, recording tools, and note taking tools. when one is having a, say, Zoom conversation with a client, obviously that conversation would be privileged. But if you're doing that with a non-client, say an expert witness or general witness to a case, then you have an issue. From a transcription perspective, it's not privileged. A question is, if you're directing the AI and what's important for you in terms of the note-taking, is that your work product, attorney work product, or is it not?
Well, I guess depends on if I'm asking the other side to produce it or if they're asking me to produce it, right?
Well played. Yeah.
No, but I mean, look, these are all issues that we're all, looking at and facing. I mean, to be honest, I've been very hesitant to use transcription tools because I'm just not comfortable that I've done a deep enough dive to understand what's happening with that information. I mean, from your voice being used by the companies to, God knows what else. I mean, there's the reports of people getting calls from what they think are their kids and the voices are being mimicked. So these are very serious issues that we're dealing with. So again, I haven't used those tools, so I really can't speak that much about it in terms of what it means in the long run, but it's something that we should all be very cautious about.
Well, we're in the area of transcription. One of the other cases in terms of on the liability side that you sent over that I thought was fascinating was use of AI transcription in the medical environment without consent.
Yeah, so apparently recently Sutter Health got sued because they were using an AI system to record the conversations that their docs were having with the patients during the consult. And so the lawsuit, I believe, is alleging that there was not proper consent by the patients to allow this to be done, which is interesting because, I've had like one or two doctors encounters where they specifically ask you, is it okay for us to do this? And so it'll be interesting to see how this case plays out as to whether or not Sutter's system ever properly notified the patients that their system was actually recording those conversations and then transcribing them for the doctors, which I assume are going into the notes that they're taking in the chart.
Like you, I've had similar doctor's visits where the doctor has said a bit of what I would consider to be a very well written script, which was as part of our process to be able to focus on you instead of focusing on the machine. We're now using an AI transcription tool. Is it okay with you if our conversation and the session here is transcribed? To which I always have said yes. I mean, it seems like I'd rather have my doctor focusing on me than taking notes.
Sure.
So I'm wondering if this was early in Sutter's process and they made some errors, or if there's another layer in terms of because one of the arguments as you drill down into the case a little bit is that this information is going to a third party vendor that is outside of the Sutter system, and I think that is an additional breach of privacy that is a concern for the plaintiffs.
Well, and I guess it goes to the informed consent piece of it, right? That if they're telling the patient, hey, we're recording this and it's being transcribed, are they truly disclosing exactly what's happening? Because quite frankly, the doctors don't know exactly what's happening, right? It's maybe the management at Sutter who's had discussions with this AI company that says, oh, this is a great idea, but do they really understand what's happening on the back end in order to get that piece of information into the chart?
And I think one of the things that a lot of people are unaware of is the human feedback, which is a lot of the AI products are sending this information typically to underpaid, overworked individuals in developing countries where there's human feedback going on to confirm that the AI is getting it right, which means that there are humans out there who are seeing pictures of your stuff or hearing audio of your things. And are they likely to tie it back directly to you and say your diagnosis to your doctor? Hopefully not, but perhaps. And I think that is one area that you're right, the doctors don't know and the patients don't know.
Well, and that was underscored in I think it was a congressional hearing with a Waymo executive who confirm that the people that intervene when that Waymo is sitting in the middle of the intersection, not knowing what to do, are essentially low-paid individuals in another country. I think it was in the Philippines, that are taking over and then trying to maneuver that car out of the intersection, or fix whatever it's doing that's not proper. So that is a dirty little secret of AI. And in fact, we talked about the American Arbitration Association having their AI arbitrator, but when I went and read their website, it says, "Is this all AI?" No, there's humans that are going to review this.
Yeah. Yeah. I think last in the area of cases, I would love to know where you spend your time reading and focusing, because you always bring the most interesting things forward. So the human-only rule related to copyright protection, which was upheld by the Supreme Court, Thaler v. Perlmutter. Do you want to unpack this for us?
So essentially, the Supreme Court declined to hear a copyright case in which the lower court had essentially ruled that work product generated by solely AI from human input, meaning a human put in the prompt that resulted in that work being generated by the AI, is not protected by copyright. So there has to be some sort of substantial human input in order to make it copyrightable, which is interesting. And it opens up a whole host of things in terms of how that could have ripple effects in copyright and ownership, and whose work product is it in anyway. And I think there are safeguards now that Amazon is putting in place, because there are people who are publishing like 100 books a day or something, and they're saying, no, there's no way you're doing that. You're basically creating these with AI, and you need to have something less prolific, so to speak, in order to put these books on our platform.
It will be fascinating to see, because I'm sure at some point we're going to see a variant of a bright line test of what constitutes human input. And I could see that going a variety of ways. One argument that was probably made in some of the briefing related to Thaler v. Perlmutter is that if you are designing an AI tool, AI tools didn't just self-replicate. They came from somewhere, humans. So isn't the product of an AI thus human derived?
Yeah, I mean, these are all interesting questions, and the next step in the process, in my mind, is at what point does OpenAI come with its hand out saying, "Hey, give us our cut."
Yeah.
Right? Because you're going to have people who are going to make money off of this, and the big saying around tech now is that, a kid sitting in his or her living room can become a billionaire overnight. Well, yes, but if they're doing it on their platform, I can't imagine that OpenAI is not attempting to monetize that at some point. So it's not going to be free going forward.
I would hate to disappoint them, but perhaps they will be treated exactly the way the New York Times and Getty Images and all the others that were scraped were treated, which was 0.0001 cent for the value of your intellectual property.
Right.
One thing that I didn't put in the outline, but I think is a wise thing to bring up that is related to what we just talked about, and that is the blowback, societal blowback on what is being described as AI slop. And whether you talk about 100 books a day, or there was a restaurant in Santa Cruz that used AI to design a logo, and it went from near 5 stars down to 1 because of a very much an anti-AI, anti-putting out graphic designers out of work. The idea that the material that is being produced is identifiable and bad, and putting humans out of work, there is a risk associated with that. And from a law perspective, that may be less of an issue. I think lawyers, as we've talked about, there is a desire to be more efficient in the work that we do, not to solely rely on machines, but if there's a way to get better briefing with less human hours while still having the human input, there's not a downside to that. But I think there is definitely a risk in the greater public of an anti-AI bias.
Yeah, and it was interesting. I saw a snippet of an interview from, I believe it was the president or the chief operating officer of Plantier. He was saying something like, "Oh, AI is being misunderstood because what we're seeing is if they can make companies more efficient, then that results in having extra shifts, which means hiring." And that may be true, but what's grabbing headlines is, look, these tech companies are now laying off 4 or 5, 10,000 people at a time. And well, if you're doing that, how are you going to contribute to or control the narrative that AI isn't taking people's jobs because it's taking your people's jobs?
Right.
So it'll be interesting to see how it plays out. But I think for most people, especially attorneys, if you can somehow enhance your abilities using AI, and like, we've talked about, our firms are not huge firms, but we can stand up to firms that have thousands of lawyers. And we can do that because we are figuring out efficient ways of utilizing this tool so that we can increase and better provide our clients services that maybe wouldn't be available without those tools. So those are all things that we have to consider. But again, there is going to be certain portions of the population who I think are going to get a hit with AI. And with these robots coming on board, they're trying to change and automate how everything is done. I mean, I saw footage of a textile factory, I believe it was in India, and these workers were made to wear cameras on their foreheads so that they could record their movements to program AI so eventually a robot can replicate those movements. So who knows what's going to happen? There's so many directions that this could go, but hopefully it'll be for the betterment of humanity as opposed to something that's requiring people to go in now and hide in their bunkers.
A variant of what came up earlier, better minds than mine, the billionaire tech founders, Elon Musk, they've got this figured out, and I'm just putting my faith in them, and it'll all be fine.
Right. And for the record, this podcast stands for that, it's going to be all roses and that AI is going to enhance everything that we do.
Well, and you're laughing, and I think that the future is very uncertain at this point. And I think that there are a lot of potential benefits and there are a lot of potential risks. And embracing the benefits and being cognizant of the risks is really the only way that we can move forward. None of us can control the future.
Right. And I think being informed is the best way to calm a lot of your fears about this, right? Is that, okay, let's understand what's happening and let's see how it's developing and what checks and balances are being put in place. But ultimately, the idea that this has to be an industry that's unregulated and unchecked, someone has to think about it differently because we know how that plays out when industries have no boundaries. And I don't think we have faced a tool or a product that's this powerful before, other than the atom bomb, maybe, right? So there has to be some safeguards put around it. And the owners of these products have to understand, well, do you want your product to have longevity, or do you want to just make the most powerful thing that then just blows everything up? And that's a reality that they have to come to grips with.
Fortunately, on the regulatory side, and this just popped up in my feed just now, OpenAI is coming out with a new product called Skynet. It's supposed to be a perfect regulatory process. And on that fine note, I think we should round off with, you brought up the AI documentary, which I will let you pronounce this time.
Apocalyptimist. Well, hopefully we'll check it out in the next couple of weeks and report back on what it's predicting. And what's interesting about that documentary is that they did interview Sam Altman and the CEO of Anthropic and a lot of people who are very much involved in this industry. So we'll see what they have to say.
Very cool. Anything else you think we should cover today?
No, I think we covered a tremendous amount of stuff in a good amount of time.
I would agree with you. So thanks everyone for joining us. Thanks, Shahrad, for being on as always.
Thanks for having me.
Yeah. If you have anything that you want to bring to our attention or you want us to cover, email us at podcast@coopers.law. And for all of you doing justice out there, happy hunting.